I'm Jean-Nicolas Maillard from Steptoe & Johnson in Brussels. We have the pleasure of welcoming today at the IBC Antitrust Conference in Brussels, David Viros, who is the Chief of Staff and Head of International and European Affairs at the French Competition Authority. David and I have just been this afternoon on a panel, Enforcers panel, gathering 5 competition authorities in Europe, where we had very interesting debates, and maybe we can start with that, David. David, well, actually, could you maybe introduce yourself in a few words and tell us about your background and career to date?
Okay, so my name is David Viros. I'm Chief of Staff to the President of the Autorite de la Concurrence, and in that capacity, I am in charge of international and European affairs, and I also deal with institutional matters at a domestic level. And I was, prior to joining the Autorite, I was in private practice for a couple of years.
So, David, we started this panel this afternoon discussing cooperation between national competition authorities, and I know as a matter of fact that the French Competition Authority has collaborated on a very regular basis on cases and outside of cases in other national competition authorities in Europe. A very rich debate around this issue, and in particular, I would like you to tell us a little bit more about your cooperation with the German Federal Cartel Office.
Okay, well, we decided last year to engage in a joint study with our German counterparts on the issue of data and competition. And the idea is to look at this sort of novel issue, which has also attracted a lot of interest from, for instance, the CMA or the German Monopol Commission. And our aim is to provide a sort of general guiding principles and maybe a first look at an issue which has not necessarily been addressed in the context of competition enforcement, but which nonetheless is of interest to stakeholders throughout Europe. So this is what we're trying to achieve, and we're sort of building on the precedent of our cooperation with the CMA on closed and open systems.
Right, so thank you for these explanations about what you are currently doing with the Federal Cartel Office in Germany. You announced last week a new form of cooperation as well, bilateral cooperation with the Spanish Competition Authority. Could you tell us a little bit about this initiative?
Yeah, well, the general idea is for us to foster ties with neighboring agencies. And this we have done with, for instance, the Bundeskartellamt by convening every 2 years a meeting with our senior staff and presidents to discuss current issues and also organize a conference. And the idea with our Spanish colleagues is also to meet at regular intervals and have sort of frank and regular exchanges on enforcement, on general policy issues. And the first meeting we had last week proved highly useful, very fruitful, and we are really hopeful that we can pursue this effort in the years to come.
So David, switching maybe to a different topic, 2015 has been a very eventful year for the French Competition Authority, which have seen a number of changes in these procedural tools. Could you tell us a little bit about the changes?
So yes, actually, 2015 has witnessed a number of changes to our key enforcement tools, namely leniency and settlement. Regarding leniency, we revised our notice on leniency last April, and we introduced a number of changes which should increase the incentives for firms to come and apply for leniency before the French authority. And these changes in part reflect the changes which were brought to the model leniency program in 2012, which is elaborated in the context of the ECN, and also as a reflection of a 10-year survey we conducted on the concrete operation of our program and in order to obtain some feedback from stakeholders. And basic improvements concern summary applications, the fact that we're going to issue a press release whenever we conduct dawn raids in order to ensure a sort of level playing field and allow firms which were not inspected to also apply for leniency. And we also, for the sake of legal certainty, introduced brackets to which firms can refer and on the basis of which they can anticipate the discount they may obtain through leniency applications. So this is a really welcome improvement, and we're looking forward to actually increase the success of our program, which is already not doing too bad because we've had 11 decisions so far for a total of around 3 billion euros in fines following leniency applications. And then the second change concerns settlements, and that was introduced by the Loi Macron, so it's a change in statutes, and it allows us basically to settle a case more or less along the lines of the commission settlement procedure. There are, of course, national specificities. Settlement would occur after the SO, and parties are in any event granted full access to the file, but this should allow us to reach an agreement on the amount of the fine, something we could not do under the current settlement procedure, and we hope that with the system, we will in particular reduce the litigation before the Court of Appeal on the decisions we adopt, and that should lead to considerable administrative efficiency and savings. So this is something we really appreciate.
Besides this change in procedural tools, there was also a considerable expansion of the scope of action of the French Competition Authority, which inherited new powers, new territories to regulate. Could you tell us a little bit about that as well?
Yeah, sure. Well, again, the Loi Macron I mentioned previously has entrusted us with new missions concerning regulated legal professions. Just to name a few, notaries, bailiffs, etc. Those professions currently operate with regulated tariffs and strict conditions as regards access to the market and rules on establishment. And the government has decided to entrust us with powers which are purely advisory, but will imply in practice a detailed monitoring of the market and an implication in the drafting of regulations pertaining to these professions. And this will have an impact on our activity, and therefore we have been given also increased resources and staff, and that is very welcome. So we should have, by the end of the year, 192 permanent employees within the Autorite to cope with these new missions as well as with our core missions.
So more to see on that space.